Assalamualaikum warahmatullahi wabarakatuh, and hello everybody. My name is Nur Azura binti Muhammad Yusuf with my matrix number 2023377307. Today I would like to make my review on my case study for industrial relation, regulation and cybersecurity for Mr. Ramesh anak lelaki Madhavan versus Allies Expert Sdn Berhad with case number 3/4-492/23. First and foremost are the overview of the case study. First, the facts of the case. Second, the issue of the case. Third, the judgment. And last one is the analysis and critique. Facts of the case. The case between Ramesh anak lelaki Madhavan and Allies Expert Sdn Berhad involves a claim of constructive dismissal under Section 20 in bracket 3 of the Industrial Relations Act 1967. Coming to the issues of the case, there are four issues of the case for this trial. First one, the claimant accepted an offer of employment as a manager for Barakah Realty Sdn Berhad, managed by Elias Expert Sdn Berhad, on November 18, 2021, with a salary of RM4,500 per month. Second, the employment was to manage a palm oil plantation in Jeli, Kelantan. On 30th December 2021, Barakah wrote a letter to the company mentioned that the lease for the plantation land had not been obtained from the state of the government yet. Third one, the Barakah informed Elias Expert that the plantation lease was delayed and as a result, operations could not be commenced. The company informed the claimant in January 2022 that his salary would be reduced by 50% during this delay. Fourth one, the claimant expressed dissatisfaction over the delay and reduced salary, deeming it unfair. On August 26, 2022, the claimant submitted a letter alleging constructive dismissal. 6 days later, Barakah revoked Elias Expert's appointment as managing agent, effectively terminating the operational setup. So this is all the chronology of this issue. From on 18th of November 2021, the claimant accepted the offer from Barakah Realty Sdn Berhad through company's agency Elias Expert Sdn Berhad. On 30th December 2021, the company wrote a letter informing the lease for the plantation have yet to be received by the state government. On 21st January 2022, the claimant being informed via letter by the company regarding the delays on commencement and HQ requested to pay 50% of the remuneration. And on the 26th of August 2022, the claimant submitted his constructive dismissal letter. There are three judgments of the case that we can get from this trial. First one, the claimant was considered an employee of Elias Expert, not with Barakah. Second, the withholding of reduction of salary constituted a breach of the employment contract, qualifying as grounds for the constructive dismissal. And last one, the claimant was deemed to have been constructively dismissed without just cause. The court also ordered Elias Expert to pay RM13,500 in back wages for 3 months' salaries based on the probationary contract, and RM23,577 for unpaid and withheld salary. So the order, total of RM33,077 must be paid within 30 days, with an 8% annual interest after 31 days if unpaid. Now we're going to the analysis and critique for this trial. First one, the claimant employment contract. As the court found that there are a lot of contradicting elements in the letter of appointment, the aforementioned letter stated that the claimant was appointed as a manager for Barakah, but it was also sealed by the company's managing director, who was allegedly acting on behalf of Barakah. The employment contract was poorly drafted, creating confusion about whether the claimant was employed by the Elias Expert or Barakah. The court resolved this ambiguity in favor of the employee, emphasizing the employer's duty to provide clarity in the contract. By ruling the claimant was employed by the alliance expert Sundram Berhad rather than Baraka, the court reinforced the principle that the intermediary employer cannot evade obligations simply by claiming an agency relationship. Coming for the second analysis is a constructive dismissal. Referring to the Western Excavating ECC Limited versus Sharp 1978, Lord Denning M.R. held, "We think the word dismissal in the section should be interpreted in reference to the common law principle. Thus, it would be dismissal if the employer is guilty for a breach which goes to the root of the contract, or if he evinces an intention no longer to be bound by it. In such situation, the employee is entitled to regard the contract as terminated and himself as being dismissed." So continuation under constructive dismissal, taking Wong Chi Hong versus Cathay Organisation Malaysia Sdn Bhd into the account, as the court correctly applied the contract test to determine constructive dismissal. The claimant successfully argued that the unilateral salary reduction and lack of clear employment status constituted a repudiation of employment contract. The company's decision to reduce the claimant's salary to 50% without proper negotiation or agreement was vital. Salary is a fundamental term of any employment contract, and non-payment or partial payment amounts to a serious breach. The company's unilateral decision to reduce salaries without proper consultation process reflects poor management practices and a disregard for claimants' right under Employment Act. Refers to Malaysian Employment Act 1955, Act 265 and Regulations, Section 24(1), no deductions shall be made by an employer from the wages of an employee otherwise than in accordance with this Act. Now we go for the third analysis and critique and the remedies awarded. The court award of only 3 months back wages was a reasonable given the claimant's probationary status. This aligns with the Industrial Relations Act stipulation that probationer can receive up to 12 months back wages but does not guarantee this maximum. The 8% per annum interest after 31 days adds an incentive for employers to settle promptly to ensuring fairness in enforcement. While the court limited back wages to the 3 months, an argument could be made for more generous award within 12 months kept for probationers. The claimant resigned due to the company's action and was left in financial uncertainty during the case pendency. In conclusion, this case demonstrates a robust application of employment law principles, particularly the protection of employees from unfair treatment from the employer. However, the court and parties could have addressed certain complexities more thoroughly, especially concerning the timing of the dismissal and the employer's agency role. The decision offers critical lesson for drafting contracts, managing employers-employees relationship, and addressing breaches constructively. Well, that's all. Thank you. Have a nice day.